Thank you, sir. I'm sure we'll have some questions for you when we are done. Next is Major Stephen Lively from the U.S. Army, who's going to share with us for the next 5 minutes what was almost a lifetime worth of an experience in this area. Thank you, sir, for joining us.
Yes, ma'am. So
there you go. Nope. We have the wrong, no, we got it now. All right.
it's up now. Oh, says it's on now. Okay, thank you. So good to be here today. I'm one of those folks who flew in from Ohio, so appreciate the opportunity to be here and to tell you a little bit about what I've experienced. So right after 9/11, I was sitting in an office in Fremont and decided that I would enlist in the Army. I turned 30 in basic training. I already had a wife and 3 children. I have spent the last 13 years in the military. I was just recently promoted to major, currently working out of a unit in Pittsburgh. I have 2 combat deployments under my belt, the first 06-07, and then again in 10-11. Previous to that, I had a overseas deployment to Egypt, to Bright Star, where I worked a joint mission. So in 2008, I was working for an employer. Everything was going fine. Realized that I was having some issues and some friction as related to my drills. There was some temporal proximity to some harassment and some problems that I was having that were directly related to the drills. So retaliation from the employer. So at that point, I was later on I was terminated, and come to find out that in my hire packet, I had signed an arbitration agreement. When I was hired and onboarded, it was a packet, you know, maybe half an inch thick, you know, paper here, sign, 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 rolling through. And again, as was alluded to by the panel earlier, you know, it is rather coercive. You want the job, you're going to sign the paperwork. If you, and to think that you wouldn't sign the paperwork, well, that will cause you to have to go back into the labor pool, look for another job, and then that employer is going to ask you to sign the exact same paperwork. So you're right back in the same boat again. If you want a job, you will sign this paperwork, and this is the way it goes. So when my case was brought to arbitration, you know, there was code 394 from USERRA. The arbitrator said that that did not apply to my case. The agreement, there was, which was found enforceable by the Superior Court, did not provide for any judicial review. The arbitrator disregarded that. My experience with this is that the company that I was in arbitration with paid all the fees. You know, as an analogy I used earlier, it's kind of like, you know, playing soccer or playing football, and the home team pays for the referees, and the visiting team, you know, hey, good luck to you, and see how it turns out. So there's kind of a built-in bias where the employee, in my case, really, there's already a built-in bias. He'll never see me again. Well, he may see me now, but he'll never see me again in that capacity. But I don't know, he may have gone on to other business with this employer, and as was alluded to before, I think with the previous panel, there was, you know, there's some disclosure that has to be done, or you know, that situation. But the reality is this becomes a business relationship where I have no relationship. He'll see me, he'll rule, and I'm out. And like I had said, there were a couple of things under USERRA as well as the judicial review that were just completely ignored in my case. So to say that the law is followed, and I believe the gentleman earlier did say generally, and that may be the case generally, but there were some very critical and key components of my case where, had it been put in front of a jury of my peers, it would have been, I believe, a vastly different outcome. And so that's my experience.
So if I can summarize, because I've been getting some cues here to explain some of the lingo that you've been using. You had an employer. You also had military responsibilities in the Guard.
As a reservist, ma'am.
As a reservist. You had to, when you talked about problems with your drills, you were called out to do your service. Your employer didn't like that, and so you were terminated as a result of your doing your military service. Is that correct?
That is correct, ma'am.
All right, and so what happened is because then you brought an action because the military code theoretically protects you. But because your employer had a mandatory arbitration agreement, you had to go to arbitration. The arbitrator ruled against you in violation of rather specific U.S. code, and you had no recourse, and it turns out that the arbitrator, the so-called neutral, actually had a business relationship with your employer, so that you found yourself out of luck and without any recourse, even though the arbitrator had clearly ignored existing law that would have otherwise protected you as you were doing your service to your country.
Yes, ma'am, I believe that is the case.
Okay.
But it was speedy. It was without delay.
It was speedy, yes, definitely speedy. Okay, thank you, sir. I appreciate your being here and appreciate your sharing that experience with us. And if that doesn't rankle some of us, I don't know what will. All right. Mr. Paul Kane, Jr., partner with Paul Hastings. Thank you, sir, for being with us, and love your thoughts, and you're good. I think the mic is on, and the moment is yours, and then I guess all the mics are on. All right, so be careful what you say under your breath because the mics are hot. Very good. Thank you, sir.
Thank you. It's a pleasure to be here. I recommend the use of pre-dispute arbitration agreements because the legal system is too slow and it is too costly. Arbitration can be simple, it can be less formal, and it can be faster. And attorney's fees, including fees to my law firm and to me, are lower in arbitration. Now, some lawyers ask me, well, why do you recommend arbitration if it's costing you money? And I respond that dispute resolution should be fast and cost effective. It shouldn't be an expensive game for us lawyers. Now, I'm an employment lawyer, and arbitration is particularly well suited, in my view, to employment disputes. Ms. Gilbride earlier said the Supreme Court's been endorsing arbitration for 30 years. Actually, it's more like 50. It was back in the Warren Court days where the court decided the famous Steelworkers trilogy that went on at some length explaining why arbitrators are uniquely well qualified to resolve employment disputes. Now, I mentioned the benefits of speedy adjudication, and that may come as a surprise because some people think that defendants like to drag things out. Not true. There are benefits to all sides in having cases be resolved quickly. And by quickly, I mean in a period of months rather than a period of years. Both sides have better access to witnesses. The resolution occurs at a time before lost wages have compounded exponentially. The plaintiff gets closure one way or the other, and he or she can get on with his life. And from the employer's perspective, the dispute is resolved quickly before there's any festering issue of employee relations. Now, Senator Moorlach earlier asked the panel, the first panel, well, what do you want fixed? And of course, it's this legislature's job to consider proposed laws and enact some, but on this issue, I think the courts are doing just fine by themselves. The California Supreme Court has a regular docket of cases that involve arbitration-related issues. And in fact, I argued one just about 6 weeks ago. One of Governor Brown's appointees is Justice Liu, who seems to be emerging as the Supreme Court's arbitration expert. And Governor Brown has 2 other appointees on the court as well. Sometimes the courts enforce the agreements, sometimes the courts don't, but I think the courts are charting a pretty clear pathway for everyone to follow in knowing what's fair and what is not fair. Now, I heard a number of issues raised earlier. Ms. Gilbride mentioned waivers of punitive damages, unfair cost provisions, unfair venue provisions, unfair prevailing party fee provisions. Ms. Stebner mentioned non-mutual obligations to arbitrate. The courts already are dealing with all those things. That's not the way a responsible lawyer drafts an arbitration agreement, because if you include that stuff, it's not going to get enforced. Now, I hear sometimes that the contention that arbitration is a stacked deck, and you hear the phrase that there's a repeat player effect favoring employers. First of all, it's never been proven to be so, but second, the argument overlooks that our friends in the plaintiff's bar, like Mr. Polewski, are every bit as repeat players as I or any of my clients is. And I can guarantee, and this is similar to what Mr. DuBose said in the first panel, I can guarantee that if an arbitrator rules unreasonably for an employer a couple of times, word of that will spread like wildfire on the California Employment Lawyers Association listserv, and that arbitrator is going to be a former arbitrator. The market checks aberrational and unfair decisions. There's been a lot of talk about whether arbitration agreements are and are not negotiable. But in the real world, there's all sorts of non-negotiable terms and conditions of employment. For example, some employers give applicants or new hires non-negotiable employment at will agreements. And those documents foreclose the substantive right to acquire an implied employment contract protecting you from unjust discharge. So that contract actually changes the party's substantive rights. But no one contends there's anything improper about that.
Well, don't be so sure, but certainly as you go on.
Companies give non-negotiable intellectual property agreements at the time of hire. No one contends there's anything improper about that. And those agreements, too, change the party's substantive rights. An arbitration agreement, by contrast, simply changes the forum in which existing substantive rights are resolved. And all this
Aren't
is
there certain, I have to jump in here because I keep thinking of our, Major Lively and his circumstance. I mean, things do change. You don't have the right to necessarily challenge for a decision that's made that's contrary to existing law. You don't have the rights of appeal. That you don't have, excuse me, in situations in nursing homes when there is really no choice, and that the agreement is on page 45, or the requirement is on page 45, where you sign the 60 pages that have been prepared by either the employer or the company for which you're doing business. I mean, it's not all market-based. I think that's an assumption that I'd like you to just consider, and also, how would you respond to Major Lively's situation? Did you think, how do you deal with that?
sure. With
It's
respect,
not all as rosy, I don't think, is what you're suggesting.
I am not suggesting all is rosy. And in fact, I wish I had a dime for every time a client or prospective client came to me with an arbitration decision that was adverse and asked me to try to fix it. And I tell them, I can't. You arbitrated, you lost, and you may feel you got a raw deal, and you know what, I think you did get a raw deal. But that's one of the trade-offs you get when you enter into an arbitration agreement.
But again, the premise is that it's essentially a voluntary agreement. If it's voluntary, you take your chances. You roll the dice, you take your chances, as they say. But when it's something where you don't have much choice, how do you see that, someone who's been practicing for a while, how do you see that as providing the public with a sense that justice is fair and blind?
And the answer is that under the law, and both federal law and state law, I noted at page 1 of your staff's write-up for today's hearing, it quotes both federal law and state law that says that California has to apply to arbitration agreements the same rules of contract that apply to other kinds of contracts. And
Is that federal or state?
that's both.
Well, we make the laws here in California. See, we could change that if we felt that it wasn't fair to the consumer or the employee or even the small businesses.
You can't, because you're constrained by the federal.
By the federal. That is true. That is true.
And just 2 months ago, Justice Breyer wrote an opinion for the U.S. Supreme Court in the DirecTV case, and only 2 justices disagreed with what he wrote, and he faulted the California Court of Appeal for applying to an arbitration agreement a different rule of law that applies to other kinds of contracts.
He smacked us pretty hard, I would say.
And if substantive terms of the employment relationship can be imposed on a non-negotiable basis, then the arbitration agreement has to be subject to that same deference. As one U.S. Court of Appeals put it, a person would be laughed out of court if they contended that every term or condition of employment must be negotiable. That court gave it the example of a limited warranty. Products are sold all the time with limited warranties, and they're form limited warranties. And there are benefits to having a form contract so that, as one speaker earlier said, you don't have to negotiate your car rental agreement every time you go to the airport. Under the Federal Arbitration Act and under state law, courts have to apply that same even-handed rule to arbitration contracts. Now, you asked about the nursing home situation that Ms. Stebner commented about, and what she did not mention, however, is a case called Marmot Health Center versus Brown, in which the Supreme Court, not 5-4, but unanimously, said that in that case, West Virginia could not single out nursing homes for special kinds of treatment. Under the FAA, the court, states have to apply the same rule of contract to arbitration agreements that they apply to other kinds of contracts. Now, I've heard it said that it's not worthwhile to bring an arbitration over a relatively small amount of money, but in my world, which is employment law, the legislature has carefully enacted statutes in virtually every case providing for prevailing party attorney's fees. Now, it's true that you get your prevailing party attorney's fees at the end after you win, but I assure you that Mr. Pilevsky's colleagues in the plaintiff's bar don't charge an hourly fee for litigating the case in the meantime. They take cases on a contingency fee basis. I heard Mr. Carlson from Italian Colors.
You get paid on an hourly basis.
I get paid by an hourly basis, and as I said at the outset, I would like it to be the case that I get paid less by making dispute resolution occur more cost effectively. I love Mr. Carlson's restaurant. I've been a patron there, and I will continue to be, but I disagree with him that the Supreme Court resolved his case incorrectly. At the time the Congress passed the antitrust laws, class actions didn't even exist. And so it cannot be the case that Congress intended that antitrust claims necessarily must involve class litigation. Congress, as Mr. Pilevsky acknowledged, does know in certain cases how to carve out certain claims from the Federal Arbitration Act, and it has done that in like 12, 15, 20 cases. And it always can do that again. But until it does that, then the default rule of the Federal Arbitration Act applies, requiring states to respect it. So it's been, in summary, both California law and federal law for decades that the law favors arbitration agreements, and I think the courts are doing just fine separating out fair agreements from unfair agreements. And where the agreements are unfair, unconscionable, courts have no problem saying so and invalidating them. I don't think legislation is needed, and it, in general, would be preempted by federal law anyway.
Thank you. I think we all agree that some of this might be preempted by federal law, which is why we've asked to have some experts, such as those in these panels, to tell us what they believe would be and would not be, although Mr. Pilevsky indicates he's not so sure that will be the future. But that's what lawsuits are made of, and that's why we all enjoy it so much.
Well, actually, can I speak to that just for 10 seconds?
10 seconds.
I think it would be a disservice to pass a probably preempted law, because that would engender 5, 10, 15 years of preemption litigation, leaving businesses and individuals unclear about what law applies to them. And in particular, I saw a bill introduced in the Assembly very recently that actually made it a crime to ask for a pre-dispute arbitration agreement, even in a situation in which the arbitration is going to be FAA protected. I just think it would be unconscionable to make it a crime and to put persons under the uncertainty of wondering if they're going to be prosecuted for an agreement that federal law in fact protects.
Well, given the fact that the court is a breathing, changing instrument, I think what we're hoping to do is, again, protect the public, which is our responsibility, at the same time to respect the law and to understand it as best we can. I think in some instances it's somewhat unclear, given the fact, particularly as was mentioned earlier, when this act was initially passed, it really dealt with a very different set of circumstances than it seems to have evolved into. So appreciate your point of view, and obviously you've taken the time to join us today, and totally respect your point of view here. I think it will resonate with some of my colleagues and might not with others, but certainly worthy of hearing you out, and I think there is somewhere in between where we can find some balance, and that's part of our job as well. So thank you, sir. Appreciate it. And our last witness in this panel is Donald Falk with Mayor Brown. Thank you, sir.
Thank you for giving me the opportunity to speak here today. I'm a partner in the Palo Alto office of Mayor Brown. And my practice involves or includes, I'm also, like Mr. Olson, primarily an appellate lawyer, but my practice includes defending businesses against class action litigation, counseling them about arbitration agreements, and litigating the enforceability of those agreements. So I have firsthand experience of both with how arbitration agreements work and how class actions function in reality. And I mean, there are a couple themes here that I think that I'd like to shed some light on. One is that arbitration can be treated as sort of this unmitigated harm. I think the Federal Arbitration Act precludes that premise, and I also think it's inconsistent with reality, at least when the arbitration agreements are reasonable and fair and provide access to individual consumers and employees. And I should hasten to add that I think if Mr. Kane is the employer's side and most experienced in the employee agreements, I have more in the consumer side, a little bit on the employee side. But I think prohibiting arbitration, or in effectively prohibiting it, would eliminate realistic access to justice for many consumers, workers, and businesses with modest-sized claims. And I don't think that the original Federal Arbitration Act was designed only for Consolidated Edison and big companies. We're talking also about bills of lading, people shipping things across state lines where there were arbitration agreements. They were often between businesses, not exclusively, and it was often the sort of imbalance, what perceived imbalance, but the issue was whether you can get access to another, and I think ultimately for many, more productive and more effective dispute resolution system.
Well, I want to kind of refocus you. I don't think anyone here is, or at least the purpose of this is not to get rid of arbitration agreements. What we're trying to do is understand, you mentioned arbitration agreements that are reasonable and fair should continue. I don't think we disagree with you. The perceived imbalance, the question is whether or not arbitration agreements as they exist today are reasonable and fair, and which ones are and which ones might not be, or maybe all of them are in your opinion. But I don't think the goal here is to get rid of these agreements. What we're trying to do is understand what is federally preempted and what agreements, the benefits of arbitration, which I think we all agree there are many. The question is whether or not we are at sort of a balance, or if there is an imbalance. And as someone who has been in the front lines of this, I would hope you would address that for us.